So as promised yesterday, we're going to have y'all Durk video today. And I told y'all it was going to be a bombshell. And lordy, lord, it definitely was. Y'all hit that like button because we called this stuff out. But you know what? Let's get into it. So here we go. Government's opposition to joint motion to disqualify and dismiss indictment exhibits A through D. And as you can see, United States of America plaintiff versus Durk Banks. Plaintiff, United States of America, by and through its counsel of record, assisting United States attorneys Ian Yanello, Gregory W. Staples, and Daniel H. Weiner, hereby files its opposition to defendant's joint motion to disqualify the United States Attorney's Office for the Central District of California and dismiss the second superseding indictment with prejudice, docket number 290. The court has already denied defendant's request to recuse itself and the other judges in the Central District of California accordingly. This opposition will address only defendants' remaining claims for relief. This opposition is based upon the attached memorandum of points and authorities, the attached exhibits A through D, the files and records in this case, and such further evidence and argument as the court may permit. And you can see it's dated December 8, 2025. I thought that this would have dropped on time, and it did, but Lord, I did not know it was going to be 80 freaking pages. We're not going to read all 80 pages, first off, so that's number one. Let's just get straight into this one. Memorandum of Points and Authorities Introduction. Defendant's sweeping request to recuse any prosecutor, much less all prosecutors in the Central District of California, and dismiss the indictment in this murder case should be flatly rejected. The motion is based on factual misrepresentations, baseless innuendo, and cites no case law supporting the demand relief. Defendants fail to show any misconduct, let alone prejudice resulting from the government's decision of how and when to disclose the third-party threats at issue. Indeed, this court has already denied defendant's request to recuse the court and every other judge in the district, finding that there was simply no basis to recuse any jurist based on the threats. And given the well-established law of recusal of the prosecutor or a prosecutor requires a more stringent showing. See Young versus U.S. There is likewise no basis whatsoever to recuse any Central District prosecutor from this case. Defendant's motion should be denied without an evidentiary hearing. Dang. He said, bruh, hey, don't even get these cats they dead court. Just judge here. Take out your quail, dip it in your ink, and say denied. They like, bruh, don't give no evidentiary hearing. Don't do nothing. But I don't know if that's the right thing you want to do, because they already lied and been caught lying as well. The feds have. See, the feds fail to realize they actually did talk about a motion, and they talked about a motion of what it looks like to be prejudiced out in Oregon in their federal court. So the feds are automatically lying right off the bat, like 4 extra say. Let's continue on. Roll it. Statement of facts. Ain't that a... Come on now. All right. Significant and credible evidence established that defendant Banks is both a flight risk and ongoing danger. As previously briefed before this court, the government submitted significant evidence showing defendant Banks' continued danger and flight risk if released on bond pending trial. See docket number 167. In addition to the allegations in the indictment charging defendant Banks with leading a group of individuals who murdered SR with a machine gun and other weapons, the government submitted evidence that defendant Banks allegedly placed additional monetary bounties to solicit murders, and that defendant Banks attempted to flee the country after his co-conspirators were arrested. Judge Donahue ordered defendant Banks detained pending his murder trial December 24th. On December 12, 2024, United States Magistrate Judge Donahue ordered that defendant Banks be detained pending trial based on flight risk and continuing danger to the community. Docket number 116. The court reasoned that no conditions of release would reasonably assure the safety of the community, finding that the defendant Banks uses his money, influence, and power to endanger individuals whom he perceives as a threat. See docket 116 at 4. This court also found that defendant Banks was a flight risk based on his attempt to flee the country immediately after learning of his co-conspirators' arrest. You know what? Hold on real quick. So when they're using lyrics, right? Durk says in Federal Nightmares, delete my iCloud if they think they really own me though, right? And, that never happened. Which means what? The feds are still lying. But Nash, what does that have to do with anything? I got you. Because what that means is if Durk perceived that the feds were already on him, the first thing he would have did was deleted his shit. The second thing, the feds had snatched his damn phones out at the concert that he had a week before everything happened. So I'm trying to understand this real quick. The feds snatched his phones. He had nothing. And then what? Why didn't he just get on the plane then? I'm trying to understand how somebody is so meticulous. Y'all said his lyrics basically say that he know what he's doing. Y'all say all of this shit. But when the lyrics show that actually, you know what, bro? He might know the feds is on him, so he would have deleted certain things. Why didn't he? See, it's not making sense to me personally. Maybe it does for y'all. But if y'all like how we doing it so far, do me a favor. Hit that like button real quick. Appreciate that highly. Man, let's get on because the feds are full of shit. An anonymous caller left life-threatening messages for Judge Donahue months after the detention here in February 2025. On February 22nd, 2025, an anonymous caller left 4 voicemails on the magistrate judge's chambers phone line, motion at X2. Among other things, the caller stated that defendants Banks and DeAndre Wilson were innocent and that if they get life, I'm going to burn this mother effer down, burn it to the ground. It's not a game. The USMS notified this court and the USAO about the messages to magistrate judge. Yeah. On February 25th, 2025, United States Deputy Marshal contacted this court's chambers, notifying the court of the threats to the magistrate judge. X at USAO 37466, and AUSA assigned to this case was also copied on the email, which was the first time the United States Attorney's Office, USAO, learned about the voicemails. After learning of the messages that morning, the USAO forwarded the threats to the FBI, a communication that did not include any court staff, to see whether the United States Marshal Service, USMS, had any information about the caller. And later that afternoon, an AUSA assigned to this case responded to the Deputy Marshal email IEX at stating, Deputy Marshal, thank you for bringing this to our attention too. We have asked our FBI team to reach out to you. Undersigned counsel is aware that no other communication from the USAO or FBI to any member or employee of the judiciary regarding the threats to the magistrate judge. On March 6, 2025, the deputy marshal responded to his initial email notifying chambers about the voice messages and provided an update that investigators identified the anonymous caller and checked to see if he had any contact with the defendants in the Banks trial, which turned up negative results. An AUSA assigned to the case was copied on the deputy marshal's March 6, 2025 email. To date, investigators have not found evidence linking any defendants in this case to the threats received by the magistrate judge. Defendant Banks sought to reopen his detention proceedings based on purported new evidence. So hold on. Y'all found out who it was. Y'all didn't arrest him? That seems odd because I would imagine if I called the damn judge and I threatened to kill them and say I'm going to burn it all the way down, I would think that I'm going to be arrested. Hell, you know that happened to one of the Mender cousins in Georgia, right? So, and the little dude had a mental problem. So Sheriff Labatt in Atlanta arrested this little boy who did the exact same thing to them against him and Fonnie Willis. And all he said was, free them, F you, I'm going to make love to your wife and all this shit. And the Fonnie Willis knew there was no real threat. And they definitely knew, Sheriff Labatt knew, man, you ain't finna step to me. I'm going to put one in you. So the feds are full of shit. Because where's the arrest? Even if y'all studied this dude up and down, a woman up and down, and y'all found there was nothing, they still made the threat against a federal judge. I thought that was a damn crime because that same young man, he made some damn calls against Glanville as well. So y'all full of shit. And this is where we know the feds are trying to manipulate. It just gets worse from here. Sorry, I had to cut it off right there, bro. My bad. On April 18, 2025, defendant Banks filed an application to reconsider the magistrate judge's December 2024 detention order. That same day, defendant Banks also filed a motion to dismiss the first superseding indictment, claiming that certain rap lyrics included in the indictment's introductory allegations about greenlighting a murder were authored before SR's murder, thus alleging that defendant Banks could not have been rapping about greenlighting SR's murder. Docket number 135. In response to defendant Banks' motion to dismiss, the government obtained a second superseding indictment, which means, you know what, you're right. We didn't do our due diligence because how it was presented was actually that, yo, you was bragging about this shit when it happened. But it turns out that's not true. That removed the disputed introductory allegation on May 1st, 2025. The superseding first indictment also added a charge against all defendants of stalking resulting in death in violation of 18 U.S.C. 22618 2AB. An anonymous caller threatened an AUSA shortly after the government filed an opposition to defendant Banks' motion to dismiss on April 28, 2025. The government filed its opposition to defendant Banks' application to reopen his detention hearing. Docket 140. Among other things, the government noted that the application was meritless because defendant Banks failed to meet his burden to show there was materially new information bearing on his dangerousness in flight. Hours after filing the opposition to defendant Banks' application to reopen, the AUSA on the case received a phone call from an unknown male caller who began making threats to the AUSA, which caused the AUSA to begin recording the call. During the call, the caller stated, "Free Durk, or we're going to shoot that motherfucker up." The AUSA responded, "Shoot who up?" To which the caller said, "Shit, your ass." Let me redo that one. Since y'all had such a good-ass time with this one, man. Since y'all had a good-ass time. Hours after filing the opposition to defendant Banks' application to reopen, the AUSA on the case received a phone call from an unknown male caller who began making threats to the AUSA, which caused the AUSA to begin recording the call. During the call, the caller stated, "Free night. Oh, we gonna shoot that motherfucker." The AUSA responded, "Shoot who up?" To which the caller said, "Shit, I'll 6 out your ass." West Side. The investigation into the threats received by the AUSA was handled by an AUSA who was not a part of this prosecution team, which actually means Drew ass was not lying. Undersigned counsel is aware of no communications from the USAO or FBI to any member or employee of the judiciary regarding the threats to the AUSA to date. The investigators have not found evidence linking any defendants in this case to the threat received by the AUSA. The magistrate judge again ordered defendant Banks detained May 2025. Following a May 8, 2025 hearing on defendant Banks' application to reconsider detention, the magistrate judge denied defendant's application and maintained the court's previous order, docket number 163. The court found that defendant Banks failed to present changed circumstances that would warrant reconsideration of the December 2024 order of detention based on either dangerousness or on risk of flight, and reaffirmed its December 2024 reasoning that the allegations against defendant Banks continue to support the conclusion that defendant uses his money, influence, and power to endanger individuals whom he perceives as a threat. Docket 163 at 4. This court reviewed the detention issue de novo and ordered defendant Banks detained based on flight risk and continued danger. First thing first, Brick is my homie, so I don't even want to hear y'all get mad. Hey, you Brick! Man, look, I'd have put money on Cuz books and looked out for his youngest for school, so SMD. But to the serious nature of it all, bruh, I have to understand the Fed's position on this because it's still not making sense. They said that there was multiple calls made throughout the damn courthouse. Y'all basically said, "Oh no, none of that happened. You guys are liars." But it turns out that did actually happen. So when y'all say these things, it's like, y'all do realize y'all got to write out the reasoning why the bullshit that you're trying to spread is being spread. And then I'm going to be fair. When you get a fresh pair of eyes, that's what de novo is. Like, we're going to look at this with no recent biases, no nothing like that. Durk almost got the ability to get his ass out of here, meaning get out on bond. See, they forgot that part. They don't mention that part. The judge basically said, "Durk, you got a lot of money. That's why I'm not letting you out of here. Nothing else. That's it." They said, "Bro, you put up a couple of million." Like, bro, nigga, I ain't got a couple $100. Cash App $, Ceddy Nash if you want to help me out. But nigga, you got millions of dollars. They basically was like, bro, you up a 20 ball, homie. You gonna have to break pockets And they felt like, this is what the judge, how it seemed to me. Y'all can let me know in the comments if y'all agree or not. The judge seemed like they was basically saying, nigga, you trying to trick us with pittance. You need to put up big stacks. And since it seemed like you was trying to hide something, I think that's a part of your character. Can't really say too much on that one. They dropped the ball on that. But what I will say is this. Dirk and them, meaning Lil Durk and his people, or Lil Durk in the industry of entertainment, whether it's basketball players, whether it is sports entertainment or music entertainment, they blow through money. You have a whole series called How I Blew the Bag. You telling me that when Drew said, and he has records of Lil Durk and how he buys flights, that, yeah. Y'all only bringing up the flight shit because y'all know it's bullshit. Drew Filling is going to introduce to the courts the way that Lil Durk travels. Durk ass wake up one day and say, you know what? We're going to go to Dubai. All right. When we going? Today. Today? Yeah, we're going to go today. We're going to go to Miami. When we going to go? Oh, in a couple hours. What the So that's how he does it. The hell? And y'all damn near had nothing. That's why the first time we're seeing this flight shit after a bunch of dockets trying to defame him, it's now popping up now. Kind of crazy to say, right? Sorry about that, bro. Y'all know when the feds piss me off, I gotta go off. The court reviewed the detention issue de novo and ordered defendant Banks detained based on flight risk and continued danger. On May 14, 2025, defendant Banks appealed the May 2025 detention order to this court, docket number 159. The court heard the argument on June 2nd, 2025, and issued a written opinion on June 9th, 2025, detaining defendant Banks docket 202. Applying de novo review, the court detained defendant Banks on danger and risk of flight finding. Just like magistrate judge, the evidence before the court showed that defendant Banks uses his money, influence, and power to endanger individuals whom he perceives as a threat. And y'all just lied, and we broke that down in the last little clip, so it is what it is. The government filed a motion to impanel an anonymous jury to protect jurors and preserve trial integrity. This is all bullshit, but we gonna read it anyways. On October 6, 2025, the government filed a motion seeking the impanelment of an anonymous jury, docket number 235, among other things. The motion cited the significant media attention this case has generated, which prompted the anonymous threats to magistrate judge Ed AUSA, because the government determined the anonymous threats were relevant to its motion and produced to defense counsel, which is bullshit, because if that was the case, why the hell did Buddy call the wrong damn AUSA? Y'all literally admitted in this damn thing. So you guys are full of shit. It wouldn't surprise me. And I'm not accusing the feds of doing this shit, but it's not going to surprise me if the feds are the ones who did this. Because once again, why the hell isn't the person who made the threats to the judge under arrest? Anybody else would be in jail. Information about threats prior to filing this motion for an anonymous jury. Defendants filed their motion to recuse all judges in the district and recuse the entire USAO. And that should have happened. On November 13, 2025, defendants filed their motion and requested extreme and extraordinary relief to vacate all hearings and trial dates, to recuse all judges and prosecutors in the Central District of California, and to dismiss the indictment with prejudice. Docket number 290. The government immediately filed a statement noting at least two incorrect representations in defendants filing docket 292. The first was the parties request that the court refer this matter to an out-of-district judge for hearing as soon as practicable. Counsel for defendant Banks has since acknowledged the reference to parties was an inadvertent drafting error, which means, okay, and the second error, and they've done this shit before too, but whatever, which is yet to be addressed or corrected by defense counsel, is that the United States Attorney's Office, in carrying out a secret investigation, relayed the threats to all judges in the Central District of California, including this court motion at 1, as explained above and below. This statement, along with the repeated assertions and insinuations that the prosecution team has engaged in multiple ex parte communications with the courts, is patently false. Yep, never mind. Anyways, this court has already denied defendant's request to recuse and stay proceedings, finding there is no basis for any judge in this district to recuse. On November 18, 2025, the court heard oral argument on defendant's request to 1. Have an out-of-district judge hear their recusal motion. 2. Recuse the court and all judges in the Central District. And 3. Stay proceedings in this case. The court denied all 3 requests. The court held that there is simply no basis for its recusal, the magistrate judge's recusal, or to stay anything, reasoning that it simply is not the case that the threats in this case, where at no time has anyone thought that the defendants had any role in this. But bruh, your whole thing is this shit. Can force the judge off of this case. Argument. A recusal of any prosecutor in the Central District is wholly unwarranted. Legal standard. The separation of powers requires judicial respect for the independence of the prosecutor, which generally means that courts do not have a license to intrude into the authority, powers, and functions of prosecutors. Disqualification of government counsel necessarily invades into the role of the executive branch because it implicates the separation of powers. Accordingly, recusal of a prosecutor demands a clear basis in fact and law, demonstrating a violation of the Constitution, a federal statute, or procedural rule ID at 571, 573, cleaned up the risk of offending separation of powers principles when disqualifying an entire office of executive branch attorneys is even greater and seldom warranted. Unsurprisingly, every circuit court that has reviewed an office-wide disqualification has reversed collected cases. Such relief is an extreme remedy that is only appropriate in the most extraordinary circumstances. Before a court may disqualify even a single prosecutor, a defendant must demonstrate prejudice from a prosecutor's conflict of interest or present clear and convincing evidence of prosecutorial misconduct. Only after the court makes those attorney-specific factual findings and legal conclusions is disqualification of government counsel appropriate. This cannot be done merely as the precautionary measure. Yeah, but it can, because if I file a damn appeal and I pull this shit out, they may say yeah. So nah, that's bullshit. The mere appearance of a conflict of interest is insufficient to warrant disqualification. Lorenzo 995 FD at 1453. See also United States versus Held. Noting that the potential conflict of interest would have to be very strong before disqualification would be justified and would require proof by clear and convincing evidence of a prima facie case of misconduct on the part of the AUSA. Indeed, establishing a prosecutorial conflict of interest requires showing a more severe conflict than establishing the conflict of a judge, as the standards of neutrality for prosecutors are not necessarily as stringent. And just as the defendant cannot manipulate his choice of judge by threatening the court, what? A criminal defendant cannot cause the recusal of his prosecutor by threatening the prosecutor or having him threatened. Let me ask y'all a question. Don't y'all find this shit odd that this only hurts Lil Durk as far as the threats to the prosecutors and judge, and that they basically said, we want an anonymous jury only after they done told the damn everybody else except the defense about the threats to the judge? That's where stuff gets a little eyeball. The prosecution is very arrogante. As a person who is arrogant myself, brash, harsh, a preening, egotistical prig, dismissive of the virtuous, unaware of the happy and uncomprehending, unaware of the beautiful and uncomprehending in the face of the happy, I had to say, bruh, y'all gonna mess around, and when it's time to drop evidence, y'all gonna indulge in Brady violations. Guaranteed. Knock it to this day. Like, knock that damn door and let them know, bruh, watch what happens. Watch what I tell y'all. There's gonna be some Brady violation that's gonna happen. But let's finish this one out. If I gotta jump in, I'll jump in. But so far, nah, bruh. Y'all saying, yo, yeah, we want all of this stuff, and then y'all find out why we want all of this stuff later on. You don't think that wouldn't draw some type of suspicion? If we all are on the side of justice, shouldn't that happen that way? Imagine you. Imagine we're getting ready to, I don't know, race, right? And there's judges, there's referees, there's all of this shit. And I'm basically saying I'm the greatest one ever, I'm the greatest one ever, I'm the greatest one ever. And you say, all right, cool. So we have stipulations, right? Your shoes have to be whatever. You have to wear this, and this. And we're going about all of this shit. And then before we get ready to race, I say, oh, Judge, by the way, you know that thing that y'all have about somebody maybe ready to run onto the track while I'm running, yeah, we need to address that now. You're going to sit there and go, well, when the hell did this happen? And next thing you know, you're going to say, well, how the hell did the judge know this? How the hell did the referees know this? And you knew this? And I'm finding about this today, the day of the race? And y'all want to do what? Oh, we want to say no crowd. Or at least no crowd that can be here, that can be seen. Yeah, that's what this is. Let's continue on.